Welcome to Synthetic Reality and Authentication, New Problems in Evidence. I'm Lori Cripp-Martin, a certified family law specialist, representing all genders in marital dissolutions, parentage matters, contested child custody actions, and other issues. I'm delighted to introduce our speaker, the Honorable Curtis Carnow, retired. Judge Curtis Carnow, retired, served on the California Superior Court in San Francisco, including the complex litigation department, and held numerous leadership roles within the judiciary, contributing to statewide rules and policy on appellate practice, discovery, and court administration. A Harvard College graduate with a JD from the University of Pennsylvania, he is a former federal law clerk and an assistant U.S. attorney, and as well as an award-winning judicial educator and prolific author and co-author of leading civil procedure treatises. Judge Carnow has lectured at major law schools nationwide, taught civil litigation to California judges, and is a member of the American Law Institute. And now let's get started.
I am not Morgan Freeman, and what you see is not real. Well, at least in contemporary terms, it is not. What if I were to tell you that I am not even a human being? Would you believe me? What is your perception of reality? Is it the ability to capture, process, and make sense of the information our senses receive? If you can see, hear, taste, or smell something, does that make it real? Or is it simply the ability to feel? I would like to welcome you to the era of synthetic reality. Now, what do you see?
Well, good afternoon or good morning, whenever it is that you're watching this video. For those of us who are live, it's about 1:30 in the afternoon, California time. And I really appreciate the invitation from this bar association to talk to you about some of these emerging issues in evidence that have been sparked by the technology that you've just had a peek at. My timing on this is about 40 or 45 minutes. I will do my best to answer questions after that for those who remain, and you can always contact me through my website, which is in your materials, with any other questions. I do want to just briefly go through the materials just for a minute to let you know what's there. It's all been provided to you in advance. It appends two items. There is, number one, an article that I wrote about self-authentication. That's in the materials. And there's also the draft of the proposed Federal Rule of Evidence 707, which I'm going to talk about briefly in today's session. But the full draft and committee comments are in your materials at the end. In terms of citations, the materials include links to the Morgan Freeman video that you just saw, plus a bunch of other videos as well. And you can find them easily on YouTube. The other materials, the other sites there are a bunch of cases and sites under state authority. Of course, Justice Mark Simon's volume on evidence, and some cases that I'm going to be mentioning. The citations, if you want them, are in the materials. And then there's a list of articles, most of which I won't be mentioning in my presentation, but they're pretty interesting. And almost all of them are available online. Not all of them are behind paywalls, for example, and they will bring you up to speed on some of the confusion that's been wrought by highly convincing artificial materials that are being published. There is some materials on provenance, the concept I'll be talking about, and then other materials, including the citation to the Walter Benjamin essays that I will mention, and other things that I'll be mentioning. And then on page 4 of the materials, finally, are citations and links to other articles that I've written about artificial intelligence. But let me just drop right into today's topic. I was interested in this material. It really arose from a combination of two things. First of all, the entirely fake video clip that you had to look at, and other fake videos, and the fact that they are indistinguishable, at least to my eyes, and probably to your eyes, unless you're an expert, indistinguishable from the real thing. They are deemed, secondly, the notion of self-authentication, which a lot of people think means that you can have an item in your hand, show it to the judge, and it will literally self-authenticate in the sense that it doesn't need a sponsoring witness. So some people say, I don't think that's probably true, but it's a fascinating area for us to explore in the context of some of these emerging technologies. A couple of disclaimers. Number one, obviously nothing I say here is an indication of how I might actually rule a trial. I am still sitting on the I'm a member of the Chief Justice's Assigned Judges Program, so I may show up in various counties around the state to help out our local courts. As I mentioned, my rulings in those cases will depend on the facts and the law that's presented to me in those cases. The last caveat is that I'm not going to be so much summarizing the law or telling you what the law is today. There'll be a little tiny bit of that. But what I really want to do today is hopefully suggest new ways of thinking about the issues given the developments in technology. 3 points that I hope to make. First, even the most powerfully convincing documents, and even those that are said to be self-authenticating, will not get admitted unless there is oral testimony that lays the foundation for those things. And if the jury disbelieves some of that oral testimony after the judge has admitted the item, even the most apparently powerful document may backfire and have no effect at all. And as I'll mention later on, it's exactly what happened in one of my cases. The second thing that I want to just note is the obvious fact that almost all of the evidence, or much of the evidence introduced in today's trials, is digital. And that really challenges our old notions of authenticity and the role of the original, problems that we never had when we had a handwritten agreement or a handwritten document. The fake videos that are created by Sora 2, which is what you saw, are really, I think, just the tip of a very nasty iceberg. With digital things, the distinction between testing for authenticity on the one hand and the secondary evidence rule on the other hand, these things I think really get blurred in an interesting way. And thirdly, at the end of this, I'm going to conclude with a series of very practical suggestions about how to handle and how to object to the admission of digital evidence. First, I think we really need to acknowledge the power of the document, the power of the email, the power of the text that comes up at trial. Photos and evidence are far more persuasive very often than the witness's oral testimony at trial. It's routine to do pretty severe cross-examination of a witness with an email chain, or perhaps with a video. And the video, we think, really shows the way it is, as opposed to the way that a witness might describe it to a jury. A witness, perhaps, who can't remember all that well, or can't speak all that well, or just doesn't come across as articulate and knowledgeable, even though they may well be telling the truth and are being accurate. They might forget details, and the jury itself knows the frailty of memory. They're probably going to get reminded about it in the jury instructions. But when it comes to the picture or the actual email, they will think, well, that doesn't lie. The documents don't lie. They don't have a motive to fib. So we say. We tend to believe the documents, by documents I mean videos and photos as well, over the testimony. They are the gold standard. They are very often what makes or breaks a case. Not fallible witness testimony, so we say. So we'll get back to that apparent dichotomy in a bit, because the truth is that the admission of almost every single document, photo or video, actually does depend on oral witness testimony on the stand, whether at trial or in a pretrial 402 hearing. So, little background on the law, just so we're all on the same page. First, a quick refresh. There are 3 legal hurdles that every document really needs to pass before it's admitted. First, authentication. Second, the secondary evidence rule, and thirdly, hearsay. I'm going to be focusing on authentication. Is the evidence what the proponent claims it to be? We should be careful here because the test is not exactly whether the item is the original. And I'll be returning to what the role of the original is later on. The question is whether the document is what the proponent says it is. So if he claims it's a copy or a rough approximation of something, then that's the question. Is it really that? The secondary evidence rule, which replaced the best evidence rule in California around 1999, generally allows in copies of documents, copies of what many think of as an original. It's premised on being a faithful copy of the original. And we're going to explore the extent to which that continues to be a useful way to think about it. By the way, just an aside here, I still get best evidence objections at trial. I don't know if you've seen this, hopefully not from you, but from other lawyers perhaps. I don't know why people still do this. I think it's maybe a carryover from watching too much Perry Mason, which is something I am certainly guilty of from time to time. But best evidence is not an objection that should be made. And then, of course, the third hurdle for documents is hearsay. Documents which are authentic, they're proper under the secondary evidence rule. Nevertheless, they might contain hearsay and not be admitted. I'm really not going to be talking about hearsay today. Now, as for secondary evidence, traditionally the issue only arises after the authentication issue has been handled. It's a completely separate new issue under Evidence Code 1401. But I think we're going to find that the issues of authenticity on the one hand and secondary evidence on the other are really closely mixed in many situations. So let's briefly talk about the legal test, focusing again on authenticity, just to set part of the background. In federal court, we have Federal Rule of Evidence 901 and all the way through 903, with the admissibility of secondary evidence and Federal Rule of Evidence 1001 and following. In state court, we have authenticity, which is handled in Evidence Code 1400 and following. And with authenticity, as you probably know, it's a very low threshold. What does that mean? What it means practically is that garbage sometimes gets in. Fake stuff might actually get admitted because the authenticity barrier is so low. And you may have to argue the issue ultimately to the fact finder, to the jury. The rules of evidence are not a guarantee that only good stuff, valid stuff, truthful stuff gets in. They're just constraints that make it hopefully likely that only good stuff gets in. So here's what specifically makes authenticity a low threshold test. First of all, judges are going to resolve competing inferences about a document in favor of the proponent of the document. Conflicts are going to be said to go to the weight of the evidence. In other words, for the fact finder, for the jury. Circumstantial evidence is going to be enough. We can look to see where, let's say, the document was found, who seems to have written it, the contents of the document itself, and so on. Thirdly, prima facie case is going to be just fine. Let me pause here to illustrate by what I mean by prima facie case being more than enough or being enough. Let's say a witness, Alice, gets on the stand and she says, "This is the letter that I wrote to Bob." A witness says that, and then the proponent moves to admit the document based on that testimony, and the other side jumps up. And I've seen this repeatedly. The other side jumps up and says, "No, wait, judge, before you admit the document, I want to cross-examine that witness, maybe to show that she's lying," or something like that. And the answer is usually no. If we interrupted direct testimony every time a witness provided the foundation for a document, I think we would all go mad. But more importantly, the weight of Alice's testimony, as to that, as a judge, I don't care. Argue it to the jury. For me, the low threshold of a prima facie case is, if somebody believes that witness, would it be enough to authenticate? And if the answer is yes, it's admitted. It doesn't matter if I personally believe Alice or not, unless, of course, I'm a fact finder and I handle that issue down the road. Lastly, we can rely on presumptions to get things authenticated. Generally, they are rebuttable presumptions. I say this because there are different kinds of presumptions. They work like this. The presumptions, some of which are found in Evidence Code 1552 through 1553, they can presume the accuracy of computer information and of the digital images that are printed versions that are purported to represent that information. If there's no contrary evidence to any of these presumptions, then the presumption wins, and the presumption alone is enough to have the item authenticated. If there is some contrary evidence, then the proponent has to provide some actual other evidence and cannot just rely on the presumption. So bottom line here, I think, is when it's really hard to figure out whether or not something is authentic. In the case of computer data, for example, if it's really an authentic printout of what's inside the computer, that is going to be a problem for the party objecting to the document. Presumptions are going to allow often the proponent to win, unless the other side has at least some evidence to the contrary. Presumptions, though, actually often win out, and the document gets admitted. Next, by way of background, let me just make a contrast between what I'm going to call classical evidence and digital evidence. Classical things come into existence at a particular point in time, and they have a unique path through time and through space. They are things like a painting, like a car, a specific piece of paper, or a specific book, or a specific hand-signed letter, or maybe a hand-signed agreement. Copies can be made of these things, but whether we can detect whether there is a copy or whether it's an original, this is something that might depend on the kind of tools that we have to analyze the item. And there is a classic distinction between an original and a copy of a classic item. This completely coherent concept that we have that kind of a distinction, original versus the copy. And it's what underlies the rationale of the secondary evidence rule. Now, the notion of an original, I suggest, really only applies to these sorts of classical objects. Classical objects like the 45.52 carat deep blue Hope diamond. There's only one in the universe. Maybe the actual pipe that Einstein smoked, or the actual hat that Lincoln wore. These are all classic objects. But digital objects are not like that, I think, at all. Digital copies are usually very, very easy to make, and often they are entirely indistinguishable from anything that you might want to call a copy. They can be perfect fakes. The point was made a little bit differently by the critic and essayist Walter Benjamin in the 1930s, that's a cited in your materials. What Benjamin did is he drew this distinction between classic works of art, like a painting or a sculpture, and the works of what he called mechanical reproduction, such as prints and offsets and, importantly, photographs. Classic items have a uniqueness, an aura, Walter Benjamin said, tied to their history through time and space, and a physical location. And that is what established the authenticity of that classical item. He said the presence of the original is the prerequisite to the concept of authenticity. But when he turned to mechanical reproductions, he said, by making many reproductions, it substitutes a plurality of copies for a unique existence. These are the endless copies, one made, every one perhaps a kind of an original. These are the things that come off the printing press or developed from a negative, as many of them as you like. There is no authentic original in a way, and in a way there are no originals at all. The text of an email to you on my machine is not literally the same as the text of the email on your cell phone. It's a copy, but both could be termed an original as we pass them up to the judge to look at as authentic documents. My iPad and my cell phone and my PC all may have more copies of exactly the same thing. Not exactly the same thing, perhaps, but in maybe the important ways, the same thing. And there's another original or another copy stationed somewhere else on Yahoo servers, on Google servers, and so on and so forth. With these things, as with all digital files, like text, emails, and online agreements, and so on, we really cannot use the classic concept of an original to analyze either authenticity or secondary evidence. So we now live in this digital universe, and often the things that we want to introduce at trial are these digital things, not the classic objects. The rules on computer-generated data now are a result of a general acceptance that computers are reliable and don't make mistakes. And our Supreme Court said in Goldsmith, you've got the site in the materials, which is a 2014 case, the Supreme Court said two interesting things, which at the time were really not in any serious dispute. First, quote, "We decline to require a greater showing of authentication for the admissibility of digital images merely because in theory they can be manipulated." And the second thing the court said was, "We have not required testimony regarding the acceptability, the accuracy or maintenance and reliability of computer hardware and software." The trouble is that now we do find this. It may still be true that computers are reliable in the sense of their maintenance and accuracy, and the way their CPUs function is not something that we have to get into. But the possibilities of manipulation are no longer just in theory. They are pervasive at this point. And we really need to rethink our reliance on presumptions of data fidelity, or come up with a way to allow for a thoughtful examination of these issues at trial. So let's outline exactly what some of those manipulations are. And later on at the end, I'll discuss what lawyers can do about that situation. So manipulations. The app, Sora 2, produces a video indistinguishable from the real. While many photoshopped images are obvious fakes, and some of those are actually really bad fakes coming from governments, it's a little surprising how bad some of the fakes are that come out of governmental entities around the world. You would think that they would have better tools. But those are fakes. Sometimes you can tell, and sometimes you cannot. And some of the articles that I've provided to you in the handout, there's about 4, 5, or 6 of them, they relate to fake videos and fake photographs, which have had a real impact on people's views of very important events in our recent history. And they have shaped the public discussion of those events. But the problem that I'm getting at is a little bit more subtle than the distinction between a fake and a truthful image. In many situations, the proponent is not actually trying to pass off a fake image as an honest one. He is trying to pass off what he thinks is a real image, but just with maybe some enhancements. Widely available technology can clean up an image, fill in the interstices between video frames, make a color perhaps more or less obvious, change the hues, change the values of the colors, and otherwise make an obscure image perhaps more clear, or vice versa, the other way, make something maybe just a little less clear. And all images are actually in some way edited, enhanced, or cleaned up, perhaps with the use of a lens or a filter, or in what we might call post-production. Indeed, if we compare the photo to what a human, an ordinary day-to-day experience using only his or her eyes, photos will reveal things that humans simply can't see or simply don't pick up on, such as by freezing an instant, showing a person blinking, but in the photo, it looks like she's asleep because the eyes are closed. A photo showing a smile, which is really part of a pained grimace, or a person grabbing somebody, but actually in real life, somebody just tripped. Many digital files are manipulated between the time that they're first created and the time we view them. Often, most frequently, through what is called lossy compression. where seemingly redundant bits are tossed out, which conveniently reduces files for transmission, maybe from me to you. Lossy compression will occur. You may or may not know that it has occurred, but when it does, it irretrievably degrades the quality of the image. Files can then be reconstructed at the other end by averaging or interpolation and so on. AI is now using a process called AI upscaling, which, based on the AI's view of millions of training images, creates a really beautifully, nicely finished product. But like every other ordinary routine technique that I've just alluded to, combines elements of the so-called original item with what we might call new bits. So what is the distinction between, on the one hand, the edited or translated or just slightly cleaned up version of an original, and on the other hand, what we might call the complete fake, Sora 2 image? And the answer is not much. These are modifications that are just simply taking place on a scale of a little tiny bit to a lot. Each of these things takes elements of what we might want to call an original and recombines it. In the case of an enhanced video, for example, to get more contrast and to enable us to get an item more obviously depicted, we might take an original exposure and add or subtract pixels or other elements. With text, we might add color. With emails, we might include or cut portions of what on some devices might be a string of emails. I had a case involving texts, and there were actually two versions of this because somebody thought that the string of text really started here, whereas somebody else included an exchange that had occurred above. It was a modification done with complete innocence, but what the copies were and what the originals were was confusing. An agreement is created. These are the sorts of agreements you and I enter into all the time. Is created when you sign into a hospital, for example, when you submit your credit card and get an electronically created receipt from an online vendor, when maybe you signed an employment agreement online. Text, emails, all of these things, including the online agreement, they are all just fleeting, they are all just representations of what are otherwise fleeting electronic events. Most of these documents are just electronic, signed perhaps when you agree to the terms and conditions of a website. By doing what? By using the website, by clicking, by ticking a box, by ordering something. Now, how much of that website, of those circumstances, is going to get produced in court to show what the agreement was, to show what it is in its entirety? All the pages that led up to the ticked box, all aspects of the page, the checkout page that says here are the terms and conditions, and how close to the specific consumer's idiosyncratic experience on his or her webpage has to be produced to show what the original agreement was. How much of that has to be replicated? Even what seems to be a traditional agreement, like, for example, a publishing agreement that I just signed with a law review a couple of months ago, is not exactly the original agreement. I signed, quote unquote, a PDF associating in one file two different files or groups of data, copies of which, not the original, but copies of which, by the way, were sent to the law review, which then presumably copied into the law review's computer files, or perhaps were sent to the cloud, a third-party computer. And when all of that is printed out, let's say 2 years from now, when we have a dispute, yet another copy, this time in printed form, will be produced. The final copy, the last in a very long line of multitudes of copies in various formats, will, for the first time, actually look like an original agreement. And the irony of that, I hope, is palpable. So in this case of the fake Morgan Freeman video that we saw, we again might start with an acknowledged original. The original video, an original video, or some kind of original picture, maybe the original timbre of his voice that somebody recorded, perhaps samples of the original words. We would then remix the words, shift pixels and so on, so it looked like Freeman's voice was coming out of the lips, and the lips were synchronized with the words. The system is trained on and is fed large samples, and then it issues this remix. And I suggest that really every digital file, all the ones that I have mentioned, are in a sense a digital remix of some sort. The ones that we admit and the ones that we don't admit, they all have this aspect. Every digital file in this sense is faithless. Let me just do a brief aside on the concept of the liar's dividend before I get into what we can practically do with some of these situations. The liar's dividend. Now, given what we know and what I think the general population is sensitive to about the possibilities of fake documents, lawyers can inject doubt even when there's no reason for doubt. Can we always believe our eyes? A lawyer will say. And there are subtle ways to inject uncertainty into a situation where there's no really articulable basis for uncertainty. And this is something I think all of us know. We can cast doubt by raising our eyebrows, maybe a long pause, in an exaggerated situation, some sort of gesture in front of the jury. Yeah, there'll be an objection to it, but what's done is done. The point now, I think, is that the general population has a built-in unease about photoshopping and other easily done manipulations. There are just too many stories about fake videos. So even when there is no reason at all to attack or to undermine evidence, even when no witness actually undermines it, the jury might still be suspicious. This is called the liar's dividend. The dash cam caught the accident? I don't know. The cell phone caught the assault? Really? The Earth orbits the sun? Who's to know? Who's to know what the truth is? And injecting that kind of doubt, in a sense, out of nothing, is the liar's dividend. Then let's move to our work in trials and what we can do about the situation. What is it now to authenticate when it's a digital item, when there's no original, as there might be with a classic object? And here's where authentication and secondary evidence merge, I suggest. With classical things like a handwritten note, we first establish the authenticity of the original, and then, under the secondary evidence rule, show that the copy in court is a fair copy. With digital files, we can't technically do that because we don't have the touchstone of the original. We have one of perhaps an infinite set of copies, and we establish that this copy fairly represents what I'll call some set of legal facts. Facts such as that I agreed to arbitration with Yahoo. Facts that I have an agreement with my service provider of some other sort. The facts that Alice sold her farm to Bob. The fact that Charlie sent a threatening email or text to David. In each case, I can't technically tell the jury that I'm showing them the very same agreement or the very same email or text that was sent in the past. I can't say that what I have here in court looks exactly like what was sent. The same line breaks, exactly the same hue of color, the same font, and so on and so forth. But what I can say is that I have, for purposes relevant to the issues in this trial, what I have is the same. You can call it an authenticity test. You can call it a secondary evidence test. The point is that the copy that I have in court is the same in certain pertinent respects, in the key respects that matter to this case. It's the same as the past historical version of the electronic file, or the assemblage of electronic files. That assemblage of electronic files constitutes a legal event, an agreement, a threat, and so on and so forth. And we are going to need oral testimony for this. People on the stand who say, yes, these are the same words. This is the same text. This is what my computer recorded. This is pretty much enough what I saw. As my article on self-authentication, which is in your materials notes, you also need to have circumstantial evidence in that context as well. And this is true even though the phrase self-authentication suggests that just holding up the document may be enough. But it is never enough You always need some background information, some background evidence to pass any of the tests under federal or state law for self-authentication. The classic test for self-authentication in state courts looks to, for example, whether the facts that are recited in the document are only known to the purported author and unlikely to be known by anybody else, thus showing that the purported author really did write it. But under that test, no one can possibly evaluate what the author might know and what other people are not likely to know unless one has an enormous amount of understanding and evidence about the context. You can't tell any of that, what anybody knows about the facts of the document just by looking at it. You need people on the stand to fill all that out, witnesses who are or aren't telling the truth. And when it comes to admissibility, as I have said, judges are almost never, ever going to judge credibility. If there's a minimal foundation, judges will let it in and have the jury decide the ultimate issue of whether or not it is what it purports to be. So even the best gilt-edged killer document or video or photo will fall by the wayside if the jury doesn't believe the sponsoring witnesses. If the word of a single witness is enough to get a text or photo or video and evidence, even if that witness is undermined or contradicted by other evidence, even if it's clear that the thing offered at trial doesn't, in some respects, even look like an older version of the digital file, what can one do to head off the admission when you think the evidence is actually a fake? What are the tools that lawyers have to challenge these sorts of exhibits, digital files? Or contrary-wise, what are the tools to avoid a fight at trial over digital documents, which are credible and which ought to be admitted, because they do honestly provide something real to the fact finder that matters to the issues in the case? The good news is that, unlike what happens on the internet and social media, courtrooms have standards. So let me provide you now, for the last part of my remarks, an arsenal of tools. Underlying most of these things is a single concept: reliability. That's the crowbar I suggest to open up this locker of tools. And here's why. First of all, some expertise may be needed to evaluate suspect digital files. Number two, judges are familiar with the rules on expert testimony, we hope. And number three, reliability is the key test to the admission of expert testimony. First, though, I'd like to think that foremost, and something completely different from what we've been talking about, is the ethical role of the lawyer. Lawyers have a duty of candor. They cannot present evidence known to be fake. Sure, it's okay to rely on a client's view of the facts, but there is an ethical limit. When you know that the client is lying, when you've got good reason to know that a digital file has been fabricated or modified in a material way, you simply cannot proceed with that. You've got to dissuade the client, or you need to resign from the case. Your obligations as an officer of the court actually supersede the obligations to the client. Bad evidence should never find its way into a courtroom in the first place. The duty of candor to the court, as I say, supersedes. Next, in what could be seen perhaps as an extrapolation of the current view of duty of candor, I suggest that parties always disclose post-production to the other side, any enhancement, as a matter of course. There's a professional organization, the Coalition for Content Provenance and Authenticity, cite in your materials, which has set forth standards on how digital enhancements and AI-generated materials could be marked so as to avoid misunderstandings or, let me be blunt, fraud. And if this isn't an ongoing duty, or it's not accepted by the lawyers on both sides as a duty, you can actually make it one by issuing discovery demands or getting the judge in a case management order to make it a duty. And as part of that process, there should be a pretrial exchange of exhibits and a meeting between the lawyers to identify any disputes on admissibility. This is routine in many federal courts, but I'm afraid it is not routine in state courts, and it should be. Next, you should issue requests for admissions, RFAs. Request that a document is authentic. Get the other side to agree to that long before trial and pinpoint disagreements. In state court, you should also issue at the same time Form Interrogatory 17.1, which demands the basis for any refusal to admit an RFA. Next, you may need to examine another side's computers that are owned or operated by parties in the case. This can be hard to get, but the results can be decisive. I'm reminded of a 2018 case cited in your materials, People versus Janelnik. Let me quote you something from that case, from the Janelnik case. One of the claims in the lawsuit was for age discrimination, and one of the key documents was an email produced in discovery by Janelnik, purportedly sent to him by the employer. The email concerned Janelnik's failure to file sales reports and contained language concerning Janelnik's, quote, aging memory and, quote, senility. A forensic examination of Janelnik's external hard drive in October of 2013, however, disclosed a version of this email without any reference to Janelnik's age or senility. And then there's a case I had. A demand for documents had gone out early in the case, and as to a certain category, there was nothing. And the written response to the demand was, there isn't anything. We don't have it. No such document. Fast forward, it's a few days before trial, and the document was just found. It just showed up. It was a miracle. Suspicious because the newly found document had just the words in it that made the producing side needed to help win the case. Should I have barred this item from trial? In state court, unlike federal court, there is no continuing duty to update discovery responses in order to make them continuously correct. So, unless there's a finding that a prior response was deliberately false, it's pretty tough to block admission of this newly found document. And in this case, number one, there hadn't been a final supplemental discovery demand. There should have been, I guess. And in this case, the issue wasn't that the previous response was false. The suggestion was that that previous response had actually been true, and the new document was false. So the document came into evidence. But the circumstances of its new finding sunk the case for the proponent. The fact finder didn't trust it. It backfired. So assume now discovery is pretty much done. Maybe there's a disagreement that you've pinpointed on admissibility. This can be handled perhaps in a motion in limine. We've now set the groundwork for a pretrial hearing, so-called 402 hearing on admissibility. These hearings, I suggest, should be done as early as possible because the ruling can affect trial strategy, including which witnesses need to be subpoenaed to trial. This, unfortunately, is contrary to what often happens in state court, certainly in cases where you don't find out who your judge is until the morning of trial. And in other cases, the judge may not be known until it's really too late. It's awkward. But to the extent possible, these are hearings that occur weeks, and in cases that I had as a single assignment judge, including in complex litigation, sometimes months before the actual trial date. So we're at the pretrial conference, whenever it may be. It may be that the reliability of a proposed electronic item needs to be tested. It needs to be shown by one party or another fake, or it has to be shown to be a fake. Or, and I'll get to this in more detail, it's sufficiently misleading, so it shouldn't come into evidence. And this may need experts, which is also unfortunate because now we're talking about sometimes great expense. But experts can testify on indicia of manipulation and trickery. The eye movement, the way jaw lines are carried from frame to frame, signs that a watermark which are imposed automatically by Sora and other AI apps, has been covertly removed. The point here is that, setting aside the expense issue, that making the problem one of expertise is very good for the party objecting to the document, because then that allows the judge to use traditional rules about reliability and bar the evidence at trial. Judges are far, far, far better placed than juries to evaluate expert testimony of almost any sort, I suggest. And I cover that in the expert manual that is cited in your materials. Judges can take the time. They can read all of the reports, some of which are technically admissible and some of which may not be technically admissible. They can ask questions. They can target questions to the witness on crucial issues. They can listen to conflicting evidence from experts without having to decide what is formally admissible or not admissible at trial. And thereby they can get the background that they need to really decide the reliability issue. These are all things that are sometimes very difficult to do in front of a jury. This idea of treating digital files, and in particular those files which may have been devised by or manipulated by AI, doing it as a matter of expert testimony, has been taken up by the committee on the Federal Rule of Evidence, which is proposing now FRE 707. The proposed rules contain this notion of cross-examination, cross-examining the evidence in the same way as experts, live human experts, are cross-examined on the stand. It expressly calls for the same standards of admissibility of machine-generated files as we have by experts. It tracks my comments, I think, pretty closely. And as always with experts, as I've said, reliability is the heart of where a judge needs to go in deciding admissibility. If you'd like some further ideas about how that kind of cross-examination of a machine-generated document or opinion could work, have a look at my 2018 article, which is called The Opinion of Machines, which is again cited in your work. Now, I have to say that FRE 707 probably won't help alone detect deep fakes passed off as real pictures, because it only applies when the item is concededly machine-generated. So it may or may not be useful in detecting a forgery. So back to this judge's review involving experts or not. Let me now provide another tool, this notion of provenance. Museums and buyers of artwork insist on knowing what the provenance of an artwork is going to be. Its history, its record of ownership, which is used as a guide to authenticity, just the way Walter Benjamin talked about. It's what I think of as a chain of custody, and those of you with experience in criminal law will know exactly what I'm talking about. We want evidence of every step that file took, when it was made, who made it, and the list of every consecutive owners or possessors of that digital file, all the way up to the moment that it comes into court. What is its story, we might ask? And it's true, this notion of provenance was created for classical objects, but I think we can apply it to digital objects too. Each step in the creation of a digital file can be explored. Which computers, which applications were used, what transformations were performed, who did it, who controlled that digital file up to the moment that it was brought into court. And if there's a gap in this provenance, in this chain of custody, if you will, then that's your red flag, which is explored perhaps ultimately to have the item not admitted at trial. Now, as one of my very last points, let me remind you of Evidence Code Section 352 in state court. There's an equivalent, of course, in federal court, FRE 403. And both of these allow a judge to exclude evidence to avoid unfair prejudice, confusion of issues, that is, evidence that could mislead the jury or distract them from the main issues. 352 is a very, very powerful tool. Think of this. Otherwise admissible evidence. It's relevant. It has enough to show authenticity. The secondary evidence rule has been met. There's no hearsay problem. And still, the evidence could be excluded under 352. Not only that, the issue is a matter of the trial judge's discretion. And so theoretically, at least, it should be very difficult to overturn on appeal. Now, 352 deserves its own half-day course, but let me just make a few notes. How might it work with digital files? Take the Morgan Freeman video, for example, that I showed you at the beginning of this session. It's a fake. Now, does that mean that by definition it's not admissible? Not at all. Not at all. As I said, all digital files are faithless. Some get in and some don't. A party might be offering that video to try to admit it because it's shown to display exactly what Morgan Freeman actually sounds like, with no pretense at all that he made the video. Maybe that's relevant to the case. Let's assume it is. And it's true. The video really does tell you that Morgan Freeman sounds like that. I can be your witness because I know what Morgan Freeman sounds like in all of his movies, and I'll testify that that sounds like Morgan Freeman. So maybe with the express caveat that this is fake, in the sense that it was created by Sora 2, we might still admit the video. But could it be excluded under 352? Maybe it's too convincing, and more importantly, it's convincing for the wrong reasons, using the fictitious image and the lip syncing to very strongly suggest that this must be Freeman. And if that's the disputed issue in the case, and it must be, otherwise we wouldn't be showing this video, then the jury really may be misled by this video in the sense of believing it for the wrong reason. And that is a 352 problem. Remember, digital files, unlike classical objects, are in effect mutated copies of each other. It's very possible to print out an online version of an agreement, which also could be misleading, leaving out all the surrounding text on the website, for example, the experience of being online, the color of the font, what the links actually look like. Have a look at the case cited in your materials called Cruz versus Tapestry. It's not about this issue in particular, but you will see there the website appeared one way to the consumer and critically was described in a profoundly different way by the appellant, the appellant's brief. Now, most of these printouts, digital files, and so on and so forth, really do go through some post-production processing. They're recreations that could be a 352 issue. Now, a final word on handling these issues. When you don't have the luxury of a 402 hearing, and you have some very complicated situations. After all, most cases really don't go to trial. Settlement and pretrial motions like demurs and motions to dismiss or summary judgment take care of most cases. And also posing a real problem here are short cause cases, like in some family law cases, small claims, and so on and so forth. And there's no time for some of the tools that I've noted. Surprises are likely, and summary judgment fact issues can easily be contrived or eliminated with declarations that are based on fake evidence. There may be no time to find out. And unless you've done your homework in discovery with the discovery tools that I've outlined, deepfakes are going to be hard to handle. It may take some time for us, I think, as a legal community to re-examine the very low bar, the low threshold that we have for authenticity. The shift in 1999 was done in part because there was a consensus that the world of today is no longer one in which is so deeply distrusts copies of documents. The days of manual transcription and its inevitable error-ridden products have long since passed, according to the De Silva article that's in your materials. It's true that we have these guardrails in court: ethical duties, extensive discovery rights, the availability of experts, the power and the duty of the judge to exclude unreliable evidence, that make the use of what turns out to be fake evidence unlikely. But the confidence, I think, that we had almost 30 years ago when we moved to the best evidence rule has been undermined by generative AI products. And a new look at this evidentiary rule, the way that secondary evidence works now in California courts, would be wise. In the meantime, be careful out there. Thank you very much. It's been a pleasure talking with you.
This concludes today's presentation. Thank you so much, Judge Carno, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.